Judgment in the appeal of the Queen on the application of Moseley and the London Borough of Haringey.
Lord Wilson will explain the judgment of the court.
This appeal is about the extent of a public authority's duty to consult members of the public before making a decision. There is an important scheme to relieve disadvantaged people in whole or in part from their liability to pay council tax. Until April 2013, it was called council tax benefit. Central government made the rules referable to it, local authorities administered it, and central government reimbursed them for the council tax which, as a result, they had to forego. In 2010, as part of its effort to reduce the national deficit, central government told local authorities that instead, from April 2013, they should introduce a scheme of their own to be called a council tax reduction scheme. It also told them that its reimbursement to them in and after 2013-14 would be only 90% of whatever it would turn out to be in 2012-13. Local authorities therefore realized that if relief from liability to pay council tax under their new scheme was to be as extensive as under the old one, they would face a significant shortfall in their income. And the shortfall would be even greater if more people proved to be entitled to relief in 2013-14 than in 2012-13. In 2012, Parliament inserted provisions referable to the new scheme into the Local Government Finance Act 1992. One of the provisions was paragraph 3 of Schedule 1A. It provided that, before making its new scheme, a local authority should publish a draft of it and, quote, consult such other persons as it considers are likely to have an interest in the operation of the scheme, end of quote. In August 2012, the London Borough of Haringey published its proposed scheme and embarked on the necessary consultation, which continued until November 2012. Its proposed scheme was that relief from council tax should run at a level between 18% and 22% lower than the level set by the old scheme, other than for pensioners. In other words, Haringey proposed to pass the burden of the government's cut onto all those, other than pensioners, who were then entitled to relief from council tax, rather than to leave them unaffected and to meet the shortfall in other ways. In January 2013, after considering the results of the consultation, Haringey decided to make a scheme in the terms which it had proposed, subject to exempting the disabled, as well as pensioners, from the reduction in relief. By then, Haringey was able to quantify the precise extent of the reduction. It was to be 19.8% less than the current level of relief. Haringey duly brought the scheme into effect in April 2013. The case against Haringey in these proceedings is that the prior consultation of people likely to be affected, which Parliament required Haringey to conduct, was unlawful. The case failed both in the High Court and in the Court of Appeal, but it is brought to this court on further appeal by Ms. Moseley. She is a resident of Haringey who, until April 2013, had been in receipt of council tax benefit at a level which had eliminated her liability to pay anything by way of council tax. The court unanimously allows her appeal and declares that Haringey's exercise in consultation was unlawful. It holds that a major purpose of this consultation was to apply a democratic process to the evolution of Haringey's scheme, and that Haringey was obliged to conduct it fairly. Although the statute made clear that the subject of the consultation should be Haringey's proposed scheme, rather than a variety of possible schemes, the court holds that consultation about a scheme is unlawfully incomplete without reference, in outline, to arguable alternatives. In this case, the alternative to reducing the level of relief from council tax, which of course was to pass the effect of the government cut onto the most disadvantaged of its residents, was for Haringey, like a quarter of other local authorities in England, to maintain the relief at its previous level and to absorb the shortfall, either by raising council tax, or by reducing expenditure on services, or by resorting to its reserves. The trouble is that in its consultation documents, which this court has analysed in detail, Haringey in effect presented to its residents as a foregone conclusion that the shortfall should be passed on to recipients of the relief, and that the only question was whether certain categories of them should suffer less than others. So, even though no doubt some of those consulted would have realised that in principle there were other options for absorbing the shortfall, Haringey did not explain to them, even in outline, why the options had been rejected. On the contrary, it suggested that they were irrelevant.
Thank you. The court is now adjourned.